I may be asking. This honorable court passed.
Please use the mic properly.
This honorable court passed order to have notice of the party, but family judge quota want of territorial jurisdiction. The problem is that yesterday it was the day that family judge quota. I requested not to proceed. This court has passed order. Unless a stay order is there, I will proceed. The date is fixed 7th 8. So let it be placed after launch for the interest of justice, subject to the day or stay.
File
After
your
launch.
memo, it will come. File your
Let
memo.
it be placed.
Yes, Mr.
After
File your
launch,
memo. Give your memo.
Hello.
Yeah.
Tied up matter, my lord.
Give it. Give it.
Item 239. I pray for an interim bail. I file a IA for interim bail. Lordship kindly direct to obtain instruction in the meantime, my lord. Father of the petitioner is seriously ill, my lord. Item 239 of the weekly list, my lord.
So just now you hand over the entire petition
My lord.
with the medical document.
My lord. My lord.
Item number
239, my lord. I've already served the copy of the miscase along with the medical document.
Just a minute.
My lord.
That is BLAPL number 7885
My
of
lord.
2023.
My lord. IA number 1041 of 2023.
That is 1041
of 2023.
It has come on record. देखी देवे
Asini
number ta tipi दियंतु मगे दियंतु IA number 1041 of 2023. This is an application for interim bail on the ground of ailment of the father of the petitioner. Learned counsel for the petitioner handed over the copy of the interim application with the medical document in court to the learned counsel for the state, who seeks some time to obtain instruction list this matter. Gote saptah pore pakai debe शुक्रवार
come from Bhubaneswar, my lord. I pray next week, my lord.
आज 11 तारीख 4 सब रखिवा 11 तारीख भुवनेश्वर आसियो कोन कोजन. Okay, 11th.
Obliged. A small prayer, my lord. Item 292 is a very small matter.
11 8. Yes.
Item 292, a very small matter, my lord. One side,
Yes.
my lord. I pray next week.
I'm not able to hear you. That is off or what? That off की कोला. Switch on कर दिया तो हाँ. Now you can.
My lord, item 243 weekly list. Surrender of extension of surrender of time. My lord, may be taken up.
What is that?
Extension of 243 item.
Okay. When you will surrender?
In any date.
Okay. Surrender date is extended till 25th of August.
Obliged.
Against the condition.
Just a minute. 25th August. I had disposed of. Hello? Okay. Yes.
Pardon to mention, my lord. Item 225. There is noting one bail action 3116 of 21. That is
225.
225 weekly.
Yes. Yes.
That is Bhavan Patna Town PS case number 3/2019, my lord. My case is, my lord, NDPS case. My case casing का PS case number 304/2021. My in this case earlier call disposed by Justice Sasikanth Mishra, my lord. That is BLPN number.
That is to be, you wait when the matter reaches, will verify. Yes.
My lord, appeal against the conviction. In the meantime, on dated 28/7/2023, the father of the petitioner passed away.
When passed away?
28/7/2023.
28?
28/7. My lord.
What is the item number?
Item number.
It is not there. It is on list for it. Give a copy of the. You have filed the interim application?
Yes, my lord.
So give a copy to the London State Council so that he will obtain instruction.
Yes, ma'am.
Okay. All right.
My lord, press admission.
I'll give it.
Namaskar. My lord, CRLMP number 296/2023. Item number 261. Would affidavit କରିବେ ସେ ଦବାକୁ ଚାହୁଁଛି ଯେ ମୋର advocate ଯେ ଥିଲେ ମାନସ କରିଛନ୍ତି ମୁଁ ତାଙ୍କୁ DC engagement କରିବି. 296 CRL number 296, item number 261.
261. You are Babita Patnaik.
Yes, sir.
So ଆପଣ ତ କାଉନସିଲ ଅଛନ୍ତି ମାନସ ଚାନ୍ଦ ଆଣ୍ଡ ଇଜ ଆସୋସିଏଟ
ତାକୁ ଡିସଏନଗେଜମେଣ୍ଟ କଲେ କାରଣ ସେ ମୋତେ କୌଣସି କୋଅପରେଟ କଲେ ନାହିଁ।
ଠିକ ଅଛି ଯେ ମାନେ ଆପଣ ଆଉ କାହାକୁ ଦେଇକିନି ଦେବେ ନା
ମୁଁ
ନିଜେ ଆର୍ଗୁମେଣ୍ଟ କରିବେ?
ନିଜେ କରିବି ସାର୍।
ନିଜେ ଆର୍ଗୁମେଣ୍ଟ କଲେ ତାହେଲେ ଗୋଟେ ଡେଟ୍ ଫିକ୍ସ ଅପ୍ କରିବାକୁ ପଡିବ।
ଆଜ୍ଞା।
Acha, what is the identity that you are this Babita Patnaik? Have you brought any Aadhaar card or any other
ଆଜ୍ଞା
identity proof?
ଆଣିଛି ସାର୍।
File it. So, ଏଇଟାକୁ I'm just keeping this matter on Tuesday. Tuesday it will come in the supplementary list because the Learned Council for the petitioner might not be aware that you will mention. So in the presence of the Learned Council, we make a mention. I'm just keeping it for today. All right. Mrs. Babita Patnaik, Learned Council submit that she wants to disengage his counsel and want to argue the matter herself. It's all right. Now then you fix it on in the supplementary list. Bring it on the supplementary list. Please this matter on 11th of August 2023. The name of Mr. Manas Chand and his associate shall not be reflected in the cause list. In the alternative, it should be reflected in person. Okay, it will come next Friday. Get ready.
ଆଜ୍ଞା।
Pardon to mention, ma'am. Conviction or fresh admission?
Yes,
Pardon to mention, ma'am. Fresh admission conviction.
give it.
Fresh bail matters, my lord. Fresh bail application.
Yeah.
So let's
Like week list item number 7, my lord, kindly take up 1 week after.
No. Let the matter reach you.
Beg pardon, Your Lordship. I am mentioning one interim application, my lord. Extension of interim bail. Your Lordship granted 3-month interim bail to the petitioner. The interim application number is 1008 of 2023 in BLPL number 12196 of 2023, my lord. The memo already submitted.
Okay.
Grateful, my lord.
Pardon to mention, my lord. Pardon to mention, item 294. Initially, it was at serial number 193, but subsequently, every week it was coming down the list. My lord, is juvenile bail matter, my lord.
What is the item?
294, my lord.
What is the offense here?
Offense, my lord, 302, my lord. Report
So,
already.
Mr. Das, it's a bail matter, this 294, juvenile bail matter. So bring that file, we can take up this. Item number 294.
Right.
Is mentioning it's a juvenile bail matter, and see whether those case diary and social investigation report, etc., that is available. Yes.
Publish.
Supplementary list item number 2. Lord, your Lordship may kindly have a glance to the last order dated 21/7/2023. My lord, that IA has come for flag O, my lord. I filed an IA mistakenly due to typographical error. The cause title address was incorrect. If your Lordship may kindly allow that application, I can file a consolidated cause title.
No. You have filed one IA.
Yes, my lord. For correction of the cause title, the address of the present petitioner.
I don't know. So where is the address given?
My lord, I have filed a consolidated cause title.
First of all, you should make a prayer, mention that now the address should be this, and that should be mentioned in the schedule. Where is that schedule?
My lord, mistakenly that schedule has.
No, you do.
I'll file a fresh IA.
Learned Council for the petitioner seeks permission to withdraw the interim application to file a better one, IA disposed of. Yes,
And the other portion of the Your Lordship order, Your Lordship had permitted me to furnish the names and address of the local surety. My Lord, Your Lordship may grant you a week's time, I'll file the same and give copy to the state.
Mr. Bose, Land Counsel, appearing for the petitioner, submitted that as for order dated 21/7/2023, he shall furnish, will furnish the names, address, and the documents of two local sureties who are interested to take the petitioner on bail to the Land and Council for the state within a week.
My Lord.
If same supplied, Land Council for the state shall obtain instruction regarding the genuineness of the surety, authenticity of the documents, etc. Free copy of the order be handed over to the Land and Council for the state.
My Lord. Lordship may kindly fix a date.
It will come. You file an interim application, it will come.
Yes, ma'am. Yes.
Week after, normal date will be.
Yes, ma'am. Yes.
Yes.
Item number 3.
Mr. Panda.
My lord, last time I have given the names and the sureties of the bailers. My lord has directed to Tahsildar to remain present regarding verification of the bailers' solvency and their address.
What is your name?
Bimal Kumar Lenka.
Huh?
Bimal Kumar Lenka.
Bhima.
Bimal Kumar Lenka.
You are the?
Tahsildar Balyantamani.
The submission was made by the Land and State Council that some documents were sent to you for verification and report, and you are sleeping over that matter.
My lord, I'm extremely sorry, my lord. I may be excused, my lord. My lord, the mail ID of this Tahsil, my lord, was not functioning, my lord. Mail ID, NIC mail ID of this Tahsil, my lord, was not functioning. That's why, my lord, I have not received that letter, my lord.
Now you have received.
Yes.
What is your instruction?
That is all.
What is the name of the surety you furnished?
Benundhar Sahu and Rohit Bhoi, my lord.
What has been found out, Mr.
My lord, Benundhar Sahu is the co-active, my lord. The property jointly recorded in the name of Benundhar Sahu.
And the other man is?
Rohit Bhoi, my lord.
Rohit Bhoi is another one. Benundhar Sahu, son of Karunakar Sahu, by caste Kansari.
No, Benudhar Sahu, this, it's a, it stands in the name of that.
Yes, ma'am.
Okay. What about the other one he's telling?
Other my lord, the
Rohit Bhoi, my lord.
Rohit Bhoi is the son of my lord of the active Mongoli Bhoi.
Hottada Mongoli Bhoi nahi rache.
Yes, Rohit Bhoi is the son of Mongoli Bhoi. Mongoli Bhoi, whether Mongoli Bhoi is alive or dead.
That is not verified.
So if it stands in the name of that ROR, stands in the name of
Mongoli
Bhoi, and he's a leave, how can you take, utilize that patta and take the petitioner on bail?
That instruction.
That is why if suppose he is dead, you are the sole legal heir, what is all those things have to be seen. But first of all, you should see that whether that Mongoli Bhui is, we are keeping it to next week, just take instruction. The other thing is all right, so there is no problem in that. Let us.
One password, my lord. For telephone, I am taking. One password.
It's all right. Next week it will come. The Mr. Bimal Kumar Lenka, Tahsildar Balianta, is present pursuant to the order dated 21/7/2023. And submitted an explanation regarding the reason for delay in submission of the compliance report. The same is taken on record. He has also obtained instruction regarding the two local sureties, that is Benudhar Sahu, son of late Karunakar Sahu, and Rohita Bhoi, son of Mongoli Bhoi. It appears that the land stands recorded in the name of Mongoli Bhoi. When a query is made to the Land Council for the petitioner as to whether Mongoli Bhoi is alive or not, Land Council for the petitioner seeks some time to obtain instruction. List this matter on 11th of August 2023. Personal appearance of Tahsildar Balianta is dispensed with.
Item number 4.
I am in BC, my lord. Item number
Yes.
4, my lord. My
Yes,
lord,
argue your matter.
my lord, the petitioner's mother is ill for that is thyroid cancer, my lord. I have given all the documents, my lord.
IA number 762 of 23.
I have given all the medical documents, my lord.
Wait.
My lord, the petitioner is in custody since 2020, and his mother is suffering for thyroid cancer, my lord. So the doctor said to advise her to operation, my lord.
Yes, Mr. Misra.
In fact, my lord, the IA copy is not available in the case record. I will verify it in office, my lord.
This matter came on 21/7/2023.
Yes, ma'am.
And in that order, it is mentioned that the London Council for the State received the medical documents annexed to the petition and 6 1 week time. So that was handed over to you.
Court actually, it was directed to give the copy to the London State Council.
Yes.
But subsequently, perhaps he has not given, therefore that is not available in the court.
Mrs. Misra, you have not given the.
No, my lord. I have already filed with the miscase, my lord. That was filed, my lord, with miscase, my lord.
Okay. That is missing from their office file. All right. Whether I'm asking to her to give you another copy.
Yes, sir.
The matter may come after months, my lord.
You give just one more copy of the interim bail application with that medical document of the to substantiate the element of the mother of the petition. The London Council for the State submits that the interim application copy is not available in the case record, and let the London Council for the petitioner serve another copy of the interim application with the medical documents to the Land Council for the State during course of the which, on receipt of which instructions shall be obtained This address verification has been made earlier. He is a man from
My lord.
Chhattisgarh. Again, it will be delayed. Simultaneously, the Learned Counsel for the state shall obtain instruction as to whether the address given in the cause title of the bail application, address of the petitioner, is correct or not. For such purpose, the Superintendent of Police Malkangiri shall make necessary communication with Superintendent of Police Durg district in the state of Chhattisgarh. Free copy of the order be handed over to the Land Council for the state for compliance. Matter be listed. We commencing got a saptah chhad de poile. Yes, next.
My
Hand over
lord.
the copy of that interim application and the medical document to Mr. Mishra.
My lord. My lord, date early date maybe.
1 week after it will come. Yeah.
Item number 5.
Lords, here your lordship had directed the state to take inspection. Order dated 21/7.
5. An application for modification of the order dated so and so. What modification you want?
Lords, I am not in a position to furnish the cash surety.
19.5. EOW so and so sending king. Cheating amount is so and so 29 lakhs. So and so, okay.
Petitioner number 1 has been directed to pay 29 lakhs 3,240. Number 2 is 51 lakhs 96,330. 25% at the time of going on bail, balance in installments.
They are still in custody.
Yes, their accounts have been attached, so they have no funds.
What instruction you have received?
I was prayed 1 week time, my lord.
You come next week then. The submission, the reason has been given in that interim application by Mr. Panda as to what is their difficulty. Because the bail order was passed on 19/5 and more than 2 months have already passed. And they are not in a position to deposit and come out of. See that what the Learned Council for the state
Property security and furnish.
let him obtain Learned Council for the state 6 1 week time to obtain instruction on the IA order. Please this matter on 11th August 2023. Yes.
Item number 6.
What report has been received at flag X? Okay. Password.
Item number 8.
My lord, last time I prayed for time to give the copy of the deposition to the Lana State Council. I have now not missing all those depositions. I'll get the copy.
Missing.
It's not missing in my file.
From your office file.
So I pay 2 weeks after.
The Mr. Manas Kumar Chan, Land Council, appearing for the petitioner, took some more time to supply the deposition copy of the witnesses to the Land Council for the state. This matter we commencing from 21st of 21st of August 2023. Yes.
Item number 9.
May I please, your lordship, my lord, kindly have a glance of the last order. Last order, my lord, directed to obtain a my lord report with regard to the my lord surrender date of the petitioner after availing interim bail.
Wait,
And in
Land
fact, my
Counsel for
lord,
the
he
petition
surrender in right time.
interim bail correspondent.
On 17/2,
The report has come.
again, X ରେ ଆସିଥିଲା flag X.
So on in obedience to passed in so on so was released on interim bail on 18/11 so on so for a period of 3 months with a direct however they said did not surrender.
17/2 ରେ କରିଛି ଭାଇ ମୁଁ ସେ ରୋଶନ ଅଲି
Yes, Mir Rosan Ali did not surrender on 16/2/23 for which non-bailable warrant of arrest was issued against him.
ମୁଁ ହିସାବ କରିଛି 17/2 ରେ କରିଛି ସେଟା ରିଜେକ୍ସନ ଅର୍ଡରରେ ଅଛି।
ନାଇଁ ନାଇଁ ଆପଣଙ୍କ ଡେଟ୍ ଫିକ୍ସ ଅପ୍ ହେଲା 16/2 ଆଉ 16/2 ରେ ଆପଣ ଆସିଲେ ନାହିଁ ସରେଣ୍ଡର କଲେନି NBW ହେଲା that is the report of the Lennon trial court. So how did you say that you surrendered at right time?
17/2 ରେ ହାଜର କରିଛି।
ଆପଣ ଯାହା କହିଲେ ମୁଁ ସେଇ ଅନୁଯାୟୀ କହୁଛି ସେ the submission which you are making that he surrendered at right time, that is not a correct statement in view of the report furnished by the Lennon trial court.
Into my calculation ମୁଁ ବୋଲି 17 rejection order
No, that is not the thing. When bail is bail bonds are filed, the date is fixed by the Lennon trial. You might have incorrectly calculated. That's a different thing.
It was an interim bail and he surrendered in
But the counsel who was filing the bail bond must have been intimated that the date of surrender would be 16/2/2023, and accordingly the file would be placed on that day. And that Pescar is to note the date on that diary, court diary, and 16/2 must have been called. You are found absent, so non-bailable warrant of arrest was issued against you.
then
Once you are flouted means why bail would be granted.
then on the very next day 17 ରେ କରିଛି ସେଇତେ
You
report
cannot take liberty of 1 day extension.
ନା
1 day or 2 day you have none.
ସେଇଟା ମୁଁ ଭୁଲ ମୁଁ the calculation properly on 17 ରେ କରିଛି।
No, you stay there.
I'm not ମୁଁ young boy କେବେ ବି ଆଉ
Put
ଗୋଟେ
up
ମାସ
this,
ଦେଲେ
put up this
interim
matter in the second week of September 2023. Look, peruse the report submitted by the London Trial Court dated 1/8/2023, from which it appears that though the date was fixed to 16/2/2023 for surrender of the petitioner, but he did not surrender on that day for which non-bailable warrant of arrest was issued against him. However, he surrendered on 17/2/2023 and remanded to jail custody. Place this matter for consideration of the bail application in the week commencing from 4th September 2023. Yes, next.
Item number 10.
Basically, last order, my lord. Custody from 1970.
Wait.
Lord, let it come next week, but instruction not received.
Land Counsel for the state submitted that instruction is awaited. Matter may be taken up next week. Please this matter on 11th of August 2023.
Item number 11.
May I
status.
Yeah.
The last occasion, my lord, is adjourn this case first.
Status
Present
report
status
was
of the job. My lord, I have also obtained the status report of the
Status report
that
aslo.
matter is adjourned for
Hmm?
material is posted for argument, my lord.
So no bail. Look,
My lord, that maybe it may be delay in argument. My lord, let's consider
the Peru the status report submitted by the learned session judge comes special judge board dated 1/8/2023, from which it appears that the date is posted to today for
Yes.
argument. In view of the state of affair, I am not inclined to grant bail to the petitioner. Dismissed.
Affirmative, withdrawn.
Next.
Item number 13.
Please, Your Lordship. As per the last order, Lordship asked Loan Council for the state obtained the instruction from the IIC of the medical element of petitioner wife as the certificate of the petitioner wife.
What instruction you have received?
Yes, please. Clear, okay.
Offense,
In
what is the
case
offense here?
20B 2C
20B 2C, 390 kg of ganja.
No, the report which you are submitting, that shows that the wife's element is correct.
Yes.
But is in custody since when?
16 August of 2022, Your Lordship.
Oh, have you ever gone on interim bail?
Yes, Your Lordship. On 2 times, Your Lordship.
But in this very application, or earlier you filed the application?
Earlier was filed, but it was rejected by the Honorable Court on the ground of conclude the matter within 6 months. That was a
No,
fresh
it's
bail
all
matter.
right. In this particular bail application, you were earlier granted interim bail.
Yes, Lordship.
What is the date of bail?
3rd of December 2021, and another is the 1st of November
3rd of
2022.
Mr. Counsel, this bail application is of the year 2023. So, here is the question of passing any order in 21 in this application. That's why I am telling you that earlier you might have been granted interim bail. So, if so, why didn't you mention it in the cause title? Cause title, please verify. You have mentioned that it was never before this court in any form whatsoever.
No. Lordship, this time I am seeking only for an interim bail application, Lordship.
No. How can you mention incorrect thing in your cause title? You have, as it appears, you have approached this court 4 times.
Yes, Lordship.
All these numbers are there before me now.
Yes, Lordship.
Computer slip indicates how many times you have come. And in your cause
Yes,
title will mention that it was never before this court.
Oh, yes, Lordship.
So correct it, file a correct affidavit that it was earlier thrice before this court.
Okay, Lordship.
On perusal of the cause title of the bail application, it is mentioned, quote, in inverted comma, the matter out of which this bail application arises was never before this honorable court in its present form as per the instruction of the petitioner, inverted comma ends. However, on the registry has placed the details of the earlier cases filed by the petitioner, which indicates that the petitioner earlier approached this court thrice. Therefore, the petitioner has suppressed regarding his approach to this court earlier for bail. Learned counsel for the appellant petitioner submits that he will file an interim application for correction of the cause title, put up this matter after the interim application is filed. The learned counsel for the state has obtained instruction from the inspector in charge of Mona police station regarding the ailment of the wife of the petitioner, which is taken on record. File that interim application to make necessary correction in the cause title.
Please, Your Lordship. Most obliged.
Item number 14.
Yes, Mr. Sahu.
Item number 14.
Yes.
Your Lordship, on the last occasion, the interim application called for that instruction.
So it's a genuine case, is a cardiac. IA number 748 of 2023. This is an application for interim bail filed by the petitioner, Suraj Mandal, on the ground of ailment of his wife. Medical documents have been annexed to the interim application. The learned counsel for the state was asked to obtain instruction on such application. Today, the learned counsel for the state has produced the written instruction received from IIC Mathili Police Station dated 3/8/2023, from which it appears that the wife of the petitioner is bedridden and she's suffering from cardiac problem. The written instruction is taken on record. Considering the submission made by the land counsel for the respective parties, governments taken in the interim application, medical document annexed to the application, and instruction received by the learned counsel for the state, I am inclined to release the petitioner on interim bail for 1 month. While on interim bail, the petitioner shall not try to come in contact with any prosecution witnesses, shall not indulge in any criminal activities. The inspector in charge, Mathili Police Station, shall keep close watch over the activities of the petitioner while on interim bail, violation of any terms and condition, shall entail cancellation of bail. Free copy of the order be handed over to the Land Council for the state, which will be forwarded to IIC Mathili Police Station. IA disposed of, matter be listed in the week commencing from so and so. The Land Council for the petitioner shall file the surrender certificate.
Also, copy may be served in course of
Yes, yes.
Item number 15.
Yes,
Please, after people are called for.
what was called for?
Status report.
Status report. Not custody since 7
Just a minute, just a minute. So, Mr. Tripathi,
Yes, ma'am.
his submission is right that since 2/5/2022, no further witness has been examined, and only 2 witnesses has been examined out of 19. So, he's in custody since
7/1/2021, Milord. 2.5 years.
you have never been released on interim bail.
No, Milord, my instruction. No.
What do you say?
281 gram of brown sugar.
No, I'm not granting him bail or
Yes,
merit. It's only on the delayed ground, as usual, it is done. So, heard the Land Council for the petitioner and counsel for the state. Period the status report submitted by the Land Trial Court, from which it appears that out of 19 charge sheet witnesses, only 2 witnesses have been examined as on date. Stop. Since 2/5/2022, no witness has been examined, as there is no presiding officer. Land Council for the petitioner submitted that the petitioner is in judicial custody since 7/1/2021 and is a local man, and in view of the delayed disposal of the trial, the bail application may be favorably considered. Land Council for the state, on the other hand, opposed the prayer for bail and contended that commercial quantity of brown sugar was seized from the possession of the petitioner, and in view of the bar under Section 37 of the NDPS Act, is not entitled to be released on bail. Considering the submission made by the Land Council for the respective parties, the quantity of brown sugar seized, bar under Section 37 of the NDPS Act, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention in judicial custody, and since only 2 witnesses have been examined and so far in the trial court, and for more than 1 year and 2 months, there is no further witness has been examined, and there is also no presiding officer in the court since 1/9/2022. I am inclined to release the petitioner on interim bail for a period of 3 months. While on interim bail, the petitioner shall not indulge in any criminal activities, violation of any terms and condition, and shall not try to come in contact with the prosecution witnesses, violation of any terms and conditions shall entail cancellation of bail. Yes, disposed of, 3 months bail granted.
Item number 16.
So if I may please your lordship, my lord, your lordship's last order in pursuance thereof, my lord, flag X has been received.
What is the last order? Petition was taken on remand in this case, so and so, and the earlier bail application were rejected and given liberty to renew after examination of material witnesses. 23 charge sheet witness, only one witness has been examined. Okay. That was your submission.
Your lordship.
Okay. Now the report has come since then. Out of 23 numbers of charge sheet witness, one witness has been examined. So out of the remaining 9 witnesses, including the informant, are of Dhenkana. Jajpur district, 11 witnesses are official. Summons have been issued to the informant, other independent witnesses, none turned off. Okay, what is the here? What is the offense here?
My lord, 395 to 302, your lordship.
No, now this it appears that other bail applications were also filed before this court.
Yes, your
So,
lordship.
as per this that standing order, the bench which has disposed of the first bail application, it is to go to that bench. So, can you tell me that when that
Your
first
lordship's court is the court, my lord, because my first bail application was rejected in 2020, whereas the other bail applications have been rejected in 2022 and 23.
how many criminal antecedents are there?
16.
Huh?
16.
1-6.
Yes. Taking that into account, my lord was pleased to reject my first bail application and directed to renew the pair after material witnesses in the year 2020, your lordship. That
No, you are taken into custody in connection with this case since when?
my lord, I was taken on remand.
Remand on when? What date?
30/11/2019, my lord.
30/11/2019.
Your lordship.
So, in all those 16 cases, whether you are on bail,
I am on bail. I had filed an affidavit to that effect. Your lordship has reflected that in order dated 9/2/2021, 3635 of 2020.
9/2/21.
Your lordship. In 3635 of 2020. The previous bail application of this petitioner, my lord.
3635. No, flag. One, so.
Third last paragraph, in connection with the criminal antecedents, a comprehensive affidavit has been filed by the mother of the petitioner, in which it is mentioned that the petitioner has been admitted to bail in all those cases.
Yes, Mr. If he has been released on other cases and detained since 2019, and you are producing only one witness out of 23 during the span of 4 years. So, why not on interim bail let him go and or the learned counsel for the petitioner and counsel for the state. And counsel for the petitioner submitted that the petitioner was taken on remand in this case on 30/11/2019, and out of 23 charge sheet witnesses, only one witness has been examined so far in the trial court. Sure. Status report was called for from the Land and Trial Court, which also indicates the same. The Land and Counsel for the state submitted that there are 16 number of criminal antecedents against the petitioner. The Land and Counsel for the petitioner pointed out from the order dated 9/2/2021 passed in BLAPL number 3635 of 21 of the petitioner that in all those cases the petitioner has been granted bail. Considering the submission made by the Land Counsel for the respective parties, the period of detention of the petitioner in judicial custody, and the status of the trial as given in the status report, I am inclined to, while not inclining to release the petitioner on bail on merit, but I am inclined to release him on interim bail for a period of 3 months. While on interim bail, the petitioner shall not try to indulge in any criminal activities, shall not try to come in contact with any of the prosecution witnesses. He shall report before the inspector in charge of Chaudhar police station once in a week on every Sunday in between 10 to 4, and shall appear before the Land and Trial Court on each date when the case would be posted for trial. Violation of any terms and condition shall entail cancellation of bail. Disposed of.
I'm obliged, Your Lordship.
Yes, yes. No. This is BLAPL. This BLA itself is disposed of. And of course, IA is disposed of.
My lord, the IA was for interim, my lord. It might not be traced, Your Lordship.
You, after examination of material witnesses, you can.
Yes, Your Lordship. Your Lordship.
Yes, next.
My lord, offense is under section 20B2C of NDPS Act, and the petitioner is almost near about 5 years in custody, my lord. All the co-accused has been released by
Status report may be called for.
status report also in called for in earlier bail application, my lord. At I have mentioned list of dates, events of date. BLPL 7878.
In which case,
my lord,
status report was called for. In which case, you say that there are connected cases. So, whether recently any status report was called for in any other case, or those are all old status reports?
That has been called for in that BLPL, not after that.
The Land and Counsel for the petitioner submitted that the petitioner is in judicial custody since, what is the date?
14/1/18, my lord.
14/1/2018. And what is the, how many witnesses have been examined?
Out of 24 witnesses, now 17 witnesses has been 17 witnesses have been examined, and 18 has been examined in part, my lord. And
18 witnesses have been examined.
18. Witness number 18 has been in part.
And the PW18 has been examined in part. In view of the submission, let a status report be called for from the Land and Trial Court. Matter be placed on such and such date. File be placed before registered judicial. Yes.
Item number 17.
Item number 18.
May I please
18,
alert?
Mr. Satpathy. Yes.
My lord, here the petitioner is in custody since 11th of February 2019. My lordship, I have filed an affidavit lastly. One thing before your lordship take up the matter, I had committed a mistake at last occasion. On the last date, I submitted that there are 20 witnesses are to be examined, but in fact 30 witnesses are to be examined. That may be, I may be excused for that because number of witnesses, your lordship, that has been reflected in order dated 28/7/2023, that out of 20 witnesses, only 4 witnesses examined. But in fact, in place of 20, that is 30 witnesses. I have the certified copy of the charge sheet. And here the owner of the truck and the driver helper, all three, my lords, please to release them on interim bail while not considering their case for bail or merit.
No, you are in custody since 11 to 2019.
Yes, ma'am.
You are never released on interim bail.
No, ma'am.
What about the other accused persons? They were granted interim bail.
Interim bail. The owner of the truck, Akshay Kumar Naik, the helper Sushant Digal, and the driver G. Kalibabu.
You are a local man.
I'm a man, local man.
Yes, Mr.
Yes,
Hardilan and counsel for the petitioner and counsel for the state. Considering the submission made by the learned counsel for the petitioner that the petitioner is in judicial custody since 11 to 2019 and after going through the status report furnished by the London trial court, in which it is mentioned that out of 30 charge sheet witnesses, only 4 witnesses have been examined. And taking into account the submission made by the land counsel for the petitioner that on account of delayed trial, some co-accused persons have been granted interim bail, and the petitioner is a local man, and after hearing the land counsel for the state, I am inclined to release the petitioner on interim bail for a period of 3 months. While on interim bail, he shall attend the court, shall not indulge in any criminal activities. Disposed of. Yes, next.
Item number 19.
Release this matter along which ones. ଏଥିରେ ଆଉ କିଛି ଅର୍ଡର ଦରକାର ନାହିଁ କରିବା ପ୍ରଥମଟାରେ କରିଦିଅନ୍ତୁ ଅର୍ଡରଟା ତା ସହିତ ଏଇଟା ଆସିବ ବୋଲି ଲେଖିଦିଅନ୍ତୁ ହେଲା
Item number 20, my lords, may I please. My lords, your lordships by the order dated 28/7/2023 had called for instruction from both parties. Now, my lords, this is a 420 case, and your lordships wanted to know if we are ready for the amount to be recovered from us. My lords, I have obtained instruction as per your lordship's order, and I'm ready for the recovery, my lords.
I have also received the instruction, lordship. In this case, the block education officer, my lord, he has communicated the salary he has received during period of his employment during till termination, my lord. That has been given 1,59,000, my lord, in gross. After deduction of EPF and something, my lord, it will be around 32,000 deduction. Deduction of PPF and other dues, that will be 32,000.
କେତେ ଟଙ୍କା ତାକୁ ଅଛି ତାଙ୍କୁ ପାଇବାକୁ କୁହନ୍ତୁ
ପାଇବାକୁ 1,64,000 I have
କୋଉଠି
1,53,000. Lordship, the next page, lordship.
next page ରେ ବିଭିନ୍ନ heading ଅଛି. I just want that
Gross, lordship may see the gross amount is that is total disbursed in his favor by the government.
ଗୋଟେ grand total ଅଛି.
My lord.
Then gross salary ଅଛି.
Gross salary, that is the total expenditure borne by the government.
Okay, so that amount he has to refund.
My lord.
1,39,860. So deposit this amount,
my lord,
and come with the proof in the code below. Deposit. The as per the order dated 28/7/2023, the Land and Council for the state has obtained instruction from the block education officer Kaprakol that during the period of engagement, by producing fake certificate, the petitioner has received gross salary of rupees 1,39,860. Land Council for the petitioner submits that the petitioner is ready and willing to deposit such amount in the code below. In view of such submission, let the petitioner deposit a sum of rupees 1,39,860 in the court of London SDGM Patnagar in GR case number 701 of 20.
I'm deeply obliged to you.
Item number 21.
May I please? Yes, my lord, before this criminal division and the order of discharge, my lord, as the noting says that well, there is some delay in filing the report. But with regard to the delay, my lord, earlier the petitioner has approved this honorable court in a CRLMC petition from 18 to 23 that was pending.
You have given the copy to the,
Lord,
what do you say on delay?
Yes, so far the delays concerned, Lordship may record my submission that no plausible explanation is forthcoming from where perusal of the application and how he was prevented by sufficient reasons in not filing the application in the
All right, I number one, so this is an
and my
application.
second submission, Lordship kindly not. I'm afraid, my lords, whether in the meantime they have filed an application challenging order rejecting the discharge application, but in the meantime charge has been framed. Then that application, that prayer deserves a recasting. Now the charge has been framed. Let my friend verify that one.
So you are to either amend the petition or you are to file another petition.
Lordship, what has happened is at the time of framing of it was cognizance was challenged initially in a CLMC petition. During pendency of that CLMC petition, Lordship, it was posted for framing of charges. Then I filed the application for discharge. That application was rejected, against which I have filed this present report.
Right? Your
Not-
discharge petition has been rejected.
That is
Against
why I-
that, you have referred this. Now, in view of the subsequent
So
development,
that I have to take instruction. Lord.
oh, it
Sorry.
is the
Let
submission.
him verify. Let him verify.
All right. First, IA number 488 of 2023. This is an application for condonation of delay in filing the revision petition. The stamp reporter has pointed out that there is delay of 70 days in filing the revision petition. After hearing the land and counsel for both the parties and the land counsel for the standing counsel for the vigilance department oppose the prayer for condonation of delay. After hearing the land and counsel for both the parties and going through the averments taken in the interim application, I am inclined to condone the delay. Accordingly, delay is condoned. Name IA is disposed of. Come to the main application, CRLREB number 144 of 2023. This revision petition has been filed by the petitioner challenging the order dated 18/10/2022 passed by the Land Special Judge Vigilance Balangir in CTR case number 13 of 2018 in rejecting the petition for discharge filed by the petitioner. Mr. Sangram Das, Land Standing Counsel for the Vigilance Department, submits that in the meantime.
Contact, we both will take instruction, bro. Because
No, you are not sure.
No, he has to verify, bro. I have got the instruction.
Submit that he has received the instruction that charge has already been framed and stop. The Land Counsel for the petitioner submitted that he may be given some time to obtain instruction in that respect, and if charge has already framed, he will take necessary steps for filing an interim application for modifying the prayer and also take grounds for challenging the order of framing of the charge. List this matter. কেবে রখিবি কোন
Next.
18 তারিখে okay 18th of August 2023. All right. The name of Mr. Sangram Das be reflected in the cause restraints book. Yes.
Next. Item number 22.
22, one password matters, one password.
Let's may frame not, sir.
One password matters.
Maybe taken off.
Another put one password.
Wait. Yes, sir.
Maybe taken off, my lord, sir. This is the case, my lord, so my learned friend last occasion to produce that set, the entire order sheet and all this.
The thing is, I have already filed the entire certificate copy of
Lordship, if a lordship may take it tomorrow, today, my lord, after lunch in the court, no, I have to go to another court. Lordship may take it to next week, my lords. Any date.
Your
One
senior,
for fresh admission.
Your senior is held up. He is having a matter in another court.
That's
So that's why he said that it may be taken off next week.
Next week.
No, the date has been fixed on 17th, that I'm sure.
All right, put up this matter on 11/8/2023.
11 is not there. 18th.
All right.
No, 17 is the date fixed for framing of charge. Last occasion I
If
got
the
it.
charge is framed, it's all right. You will amend the petition. What is it?
Kind.
Yeah. Next.
No, 17 is charged
18,
before 17 matters.
It can only come on Friday. Okay. 11th, you are not agreeing. So the next option is to fix the date on 18. Yes,
No,
next.
11th may fix.
All right, keep it on 11. All right.
Another thing, in last order, Lordship was directed to file the certificate copy of entire order sheet. I have filed.
All right, you file.
And I have Lordship directed the London Senior Business Council to file some affidavit regarding specific role.
We'll see on that day. Next.
Item number 23.
I will pardon my lord. Item 11, that is Passover, that report was there in somewhere misplaced. But the report is there.
What report?
Your Lordship, I am before Your Lordship on the rejection of my 329 application. On the last date of hearing, Your Lordship has referred the patient to the AIMS hospital. He had gone there, and the doctor opined that to admit the patient. So he has been admitted on 2nd.
Wait. As per the order dated so and counsel for the state has received instruction from the senior administrative officer so to the effect that AIMS Bhubaneswar has the Department of Psychiatry to ascertain the mental health condition of a person. The written instruction is taken on record. The criminal division has been filed by so challenging the order dated so in rejecting the petition under section 329. In the case of the petitioner that he was of unsound mind, incapable of making his defense. As per the provision under section 1, so if it appears to the magistrate court at the stage of trial that the accused petitioner is of unsound mind and incapable of making his defense, magistrate in the first instance may take up the fact of certain incapacity, and if he is satisfied that the accused is of unsound mind, he shall record his finding, postpone the further proceedings. In the impugned order, learned trial court has mentioned that medical documents which are filed by the petitioner in support of his health condition were of 2019 before a medicine specialist and subsequently a neurology doctor in the year 2021, and no other recent document was filed. The trial court by impugned order has held that the petitioner has not filed any document from a competent doctor to show that the accused is of unsound mind, in consequence of which he is incapable of making his defense, and that 8 months have passed in the meantime and accused has failed to produce any recent document. Thereby, the trial court has rejected the petition filed by Swanson, fixed the case for recording of the accused statement. In view of the plea taken by the petitioner before the London trial court and also before this court, and since the case is now at the stage of recording of accused statement, which requires the accused to understand the question put by the London trial court and answer effectively each of the questions, let a team of doctors be formed by the director Swanson, along with any other department, if it deemed fit proper. The team shall examine the petition regarding his claim of unsoundness of mind and submit a report to this court through the Land Council for the state. Okay. This petition shall appear before so and the team of doctors shall be formed who will examine. So what has happened?
My lord, after that we had gone there. The team of three doctors opened that he has to be admitted. Thereafter, he has been admitted on 2nd of this month. Now today is his MRI test, Your Lordship.
Okay, so we are adjourning this case.
Yes, Your Lordship. Short that maybe.
Yeah, where is Mr. Naik?
Your Lordship, Mr. Naik is on his legs in another court, but we have also received the instructions.
All right. The both Mr. Land Counsel for the petitioner as well as Land Counsel for the special public prosecutor for the Republic of India submitted that in pursuance of the order dated 14/7/2023, the petitioner has been admitted in AIMS Bhubaneswar for his treatment. In view of such state of affair, the matter will be listed on 18th of August 2023. Both the parties shall apprise this court about the development made, if any, in the meantime. Yes.
Item number 24.
Number 7.
Yes, Mr. Rajiv Lochan Patnaik is not there. You have got the case diary?
Yes, ma'am.
All right. Non-appears on repeated call. Urgent the matter.
Here, what was happened in the last occasion, one IA was filed with
Yes.
some medical documents, and in the instruction was called for, and in the instruction it was ascertained that documents are fake. I mean to
IA.
say, the doctor who gave that document, that doctor is not a government document. And then OPD ticket was availed from the government hospital, and in that OPD ticket, the private doctor has given the
ହଁ ଲେଖା ହେଇଛି ତ ସେ ଅର୍ଡର ଗୁଡା ସେଇଥିପାଇଁ ପରା ଆଇ ଏଟାକୁ ରିଜେକ୍ଟ କଲି ମୁଁ ହଁ ତାପରେ ଗଲା ତ କିନ୍ତୁ ମେରିଟ ରେ ପୁଣି ଶୁଣାଯିବ ତ ସେଥିପାଇଁ ଷ୍ଟାଟସ ରିପୋର୍ଟ ମଗା ହେଇଥିଲା ଷ୍ଟାଟସ ରିପୋର୍ଟ ଆସିଲା ଯେ କାଉନସିଲ ନାହାନ୍ତି ତ ଇଟ ୱିଲ୍ ବି ଟେକନ୍ ଅପ୍ ଅନ୍ ସମ୍ ଅଦର ଡେ ଦ୍ୟାଟ୍ ଆଇଏ ହାଜ ଅଲରେଡି ବିନ୍ ଡିସମିସ୍ଡ ସୋ ଦେଖନ୍ତୁ ନନ୍ ଆପିୟର୍ସ ଅନ୍ ରିପିଟେଡ କଲ୍ ଲିଷ୍ଟ ଦିସ୍ ମ୍ୟାଟର ଗୋଟେ ଡେଟ୍ ଦେଇଦେବେ now supplementary is over ଟିକେ ତାକୁ ଡାକିଲ I'm just coming within 1 minute. Oh.
Pardon, my lord.
Yes.
My lord, the weekly list item 262, I am permitted to withdraw.
Okay. Withdrawn it. Yes.
Weekly list item number 1.
May I please, your lordship? My lord, the petitioner is the complainant in court below. Accused purchased the land from the petitioner for consideration of rupees 25 lakhs. And on the date of execution of the sale deed, handed over her 4 number of check. Accused petitioner presented that check. It was bounced. Thereafter, statutory notice was issued, failed to pay, and the petitioner filed a complaint case. Learned court below acquitted the accused and placing the ground on which learned trial court acquitted the accused. That is judgment, paragraph 9, running page 96.
Yeah.
Paragraph 9. Now it is to be seen whether from the evidence available on record, the offence under section 138 NA Act is proved or not for creating a criminal liability in terms of section 138 NA Act. The complainant must prove that the accused has issued the check for repayment of any debt which he presented for encashment, but it was returned due to insufficient of fund. After that, the complainant has issued pleader notice within 30 days, but even after receiving the pleader notice, the accused failed to make payment. The check dated 19/6/2019, Exhibit P1, was duly presented by the complainant before his bank and dishonored due to insufficient of fund on 26/8/2019, which is the check return memo. Legal notice in writing dated 11/9/2019 issued by the complainant to the accused through registered post with AD demanding him to pay check amount within 15 days from the date of receipt is the envelope returned with the unsub with postal remark of 7 days door closed log. It is also evident that the complainant has sent the legal notice in writing within the statutory period of 30 days from date of receipt of the intimation of dishonor of check. On 14/10/2019, this complainant was made this, which is well within 30 days of the period of limitation, which proved that 15 days time was given to accused for repayment of loan amount, but he failed to do so. Prove an offence under section 138 NA Act, the point is to be established by the complainant is that whether a valid check was issued by the accused to the complainant for discharge of his debt in whole or part thereof. In the instant case, the evidence of the complainant reveals that due to urgent need of money, she wanted to sell out the entire land of Eckerson 12 dismill for her medical treatment and payment of loan, and accused proposed her to purchase that land. The price of land was settled 24 lakhs only. Accordingly, she agreed to sell this land for 24 lakhs to the accused. On dated 19/6/2019, the sale deed bearing number so and so was registered by the complainant in favor of the accused for consideration of rupees 24 lakhs at the office of Sub-Register Pankos. The accused, in lieu of payment of the sale consideration, issued 4 number of check bearing so and so, total amount 24 lakh. Now it is to see whether the accused issued the check marked as Exhibit P for purchasing the land under khata number so and so, measuring 40 dismill, plot number so and the said check was dishonored for insufficient of fund. On perusal of the Exhibit P check, it is found that the Alice check is in the name of 2 account holder and same is signed by accused only, and the same is admitted by complainant para 18 of the for cross examination. On close scrutiny of the sale deed, it is found that para 1 at page 6 written as in pursuance of said agreement and in consideration of a sum of 24 lakh which has been paid by the purchaser to the vendor hereby acknowledged in cash. It is revealed that the complainant has received the consideration amount 24 lakhs in cash from the accused. On the other hand, accused stated in his examination under section 313 CRPC that he has purchased the land from the complainant, already paid consideration amount 24 lakh in cash to the complainant. He also not issued, he has not issued check, issued the exhibit P1 for purchasing land, but purchasing land. Before purchasing land, at the time of negotiation, complainant has taken 4 number of check for security purpose. After registration of sale deed, the complainant did not return the check which were given as security. PW1 admitted in her cross-examination that on 3/9/2019, she purchased stamp paper from stamp vendor for execution of exhibit P and she also signed on the backside of stamp paper. PW2 is also admitted at para 23 of his cross-examination that on 3/6/2019, stamp paper for execution of exhibit P by 6 were purchased and he had put his signature as witness number 1. And on 19/6/2019, the same was registered before SRO Panpos, Raulkela. Similarly, after purchasing land, the accused had applied for mutation of the said land in his favor before the Tahsildar Raulkela and the said proceeding, though the objection was invited, but the complainant has not filed any objection to the mutation proceeding, which was filed by the
So
accused.
your conduct, Mr. Aik, your conduct shows that for that land you have received the cash amount.
My lord.
Though you was initially issued those checks, but once you received, that is why you cooperated also and the mutation was complete.
No, mutation was not, notice was not issued to me. Here, my lord, the crux is the
How
date
can
of
mutation
execution.
be done without issuance of notice?
My lord?
Mutation,
Yes.
ଯାହା ନାହାରେ ଜମି ଥିବ ତାକୁ ନ
Without
notice କରିକି
that's why the mutation appeal and civil proceeding
that
is also
a statutory requirement. How can we
my lord, I have also lost the FIR. Kindly have a glance to charge sheet. On the self-serve ground, I have lost the FIR. Kindly have a glance to
you
the
have received the check amount of rupees 24 lakhs you have received, not returned those checks, but that is the reason why you, otherwise if you would not have got the money, whether it is acceptable that you would have cooperated in the mutation and
my lord, kindly have a glance to the sell deed, my lord. Sell deed, that is kindly have page 62. Page 62. Here, my lord, the check was issued on 19/6/2019 and sell deed was executed on 19/6/2019. If the accused has paid me cash 24 lakhs on 19/6/2019, then why he has issued the 4 number of check on the same date when the sell deed was executed? That apart, when the accused cheated me, I lost FIR. In that case, charge sheet was submitted. In the charge sheet, my lord, police mentioning that page, my lord, charge sheet 112, my lord. Paragraph 2 of the charge sheet. During
112.
My lord.
112 କହୁଛି 112 page.
My lord. 112. Paragraph 2, my lord. During course of investigation, I examined complainant witnesses recorded their statement under section 161 CRPC seized 4 number of xerox copy of check of SBI Udit Nagar which was given by the Ranjan Kumar Sahu to the complainant on production by the complainant, visited the spot, searched for the accused Ranjan Kumar Sahu in the locality, but in vain. During course of investigation, it came to light that complainant and accused Ranjan Sahu are well known each other. Bhimsen Rai has a plot at Pradhanpalli in the name of his wife Khetramani Rai, the present petitioner. When they need money, they wanted to sell the said plot. The complainant came in contact with the accused Ranjan Kumar Sahu as he is willing to purchase the plot at the cost of 24 lakhs. And they fix a date 19/6/2019 for registration. On 19/6/2019, Ranjan Kumar Sahu reached at the house of complainant and gave phone number of check 24 lakhs. On the same day, plot was registered in the name of Ranjan Kumar Sahu when complainant deposited the said check, but due to insufficient, all the checks are bounced. When the complainant tried to contact with Ranjan Kumar Sahu, he avoided. As the complainant is an old man, hence the accused intentionally cheated him, my lord. 19 ତାରିଖରେ ମତେ ସେ ଚେକ୍ ଦଉଛି 19 ତାରିଖରେ ରେଜିଷ୍ଟ୍ରେସନ ହଉଛି ଏଠି ଇଂଲିଶରେ ଆଇ ଏମ୍ ମାଇ ସିଗ୍ନେଚର ଆଇ ଏମ୍ ଓଲ୍ଡ ଲେଡି ସିଗ୍ନେଚର ଇଜ ଇନ୍ ଓଡିଆ ସେଲ୍ ଡିଟ୍ ଇଜ ରିଟିନ୍ ଇନ୍ ଇଂଲିଶ ମାଇ ଲର୍ଡ ସେଠି ଲେଖି ଦେଇଛନ୍ତି ଗୋଟେ କ୍ୟାଶରେ ଦେଲେ ସେଇଥିପାଇଁ ଲର୍ଡ କୋର୍ଟ ବିଲୋ disbelieve the case of the petition 100 my lord section 139 of NI Act.
The issue notice requisites for issuance of notice be filed by Monday. Matter be listed immediately after service of notice. Yes, next.
My lord, all four cases, my lord, same.
All.
Four check.
Yes. Registered post, speed post.
My lord, speed post.
Yes, speed
post.
Item number 2.
Let's the petitioner here is a lady. The lady is impugning the order dated 3rd May 2023 passed by the Special CBI Judge Bhubaneswar, whereby the Special CBI Judge has directed for release of the goods, whereas the condition that has been imposed has been very onerous, my lords, and therefore, my lords, those conditions has not been able to be complied with. My lords, primarily the petitioner is impugning the 3 conditions, which is that the court below is directed to furnish a indemnity bond of 65 lakhs and also to produce the jewelry and precious stones at the time as and when called by the court, and also not to mold and change the characteristics of the gold, my lords. My lords, in this regard, my lords, this petitioner has preferred this petition, my lords. My lords, the grounds on which the petitioner is preferring is that, my lords,
which is the impugned order?
My lords, order is at, my lords, Annexure 1, page number 21 to 28, my lords. And conditions are stipulated in 27 to 28, my lords.
Is directed the gold ornaments and jewelries of the petitioner be released in favor of the petitioner. Inform the I1 CBI through the Learned Public Prosecutor CBI Bhubaneswar for information and necessary action. And further directed the so for interim custody of the petitioner after thorough verification with the original gold and jewelries purchase vouchers and identification of the petitioner with condition that this indemnity bond is there.
Yes, my lords, indemnity bond and my lords,
65 lakhs.
65 lakhs, my lords.
IO shall prepare with that. There is no IO shall prepare a detailed list. Obviously, he has to prepare.
My lords, that is not challenged, my lords. I am challenging serial number 2 and serial number 5, my lords.
2
and 5, my lords. Serial number 2, 5 and 65 lakhs indemnity bond.
2 photographs of ornaments and jewelry is clearly showing the nature and make.
No, my lords. My lords, 4 and 5, my lords. Apologies, my lords, 4 and 5.
The petitioner shall not sell, mortgage, melt, or change the status of the gold ornament. How this condition is irrelevant?
My lords, secondary evidence can be produced before the court, my lords. My lords, it is settled law also.
Ultimately, because it may be necessary for the purpose of identification, and maybe it has to be proved that so many things. How can you sell that? You are now keeping it as an interim custody. You can use it, it's all right, but you cannot sell it. That is the reason gold ornaments that has been released in your favor. But
The petitioner here is the prosecution witness also. It's
Hmm?
not an accused named the FIR also.
No, what is the stage of trial now?
My lord, charge sheet is already submitted. My lord.
What is the offense here?
My lords, it's an offense primarily involving chit fund matter, my lords. And based on the Subroto Chotoraja's matter, my lords, the Supreme Court's order, the CBI had taken up the case in relation to the chit fund matters. And
you are related to any accused or
my
not?
lords, I am one of the, I am the wife of the accused who have been arrested in 26/9/2022, and I was not named in the FIR. But my husband's role was that, my lords, he was delivering professional services to the company. My lords.
It's all right. So maybe that the case of the CBI is that your ornaments were purchased out of the cheat fund properties.
That's the sole case on which they are basing upon.
That is the reason why you cannot sell that. You are given the custody, you cannot sell that. So what is the problem now?
My lords, Sundarlal Lambalbai case, my lords, where the Supreme Court is permitting, my lords, to produce the court through secondary evidence, my lords.
Once you sell it, how can it be?
My lords,
once you sell it, these gold ornaments, etc. So unless it is proved that yes, it is not of the
my lords,
persons,
invoices,
then
the petitioner is providing the detailed invoices, and my lords, the petitioner is relying upon a circular, which is at page
yes,
number.
where is Mr. Nayak?
Mr. Nayak is on his legs in another court, Your Lordship. May I pray for a pass over? Mr. Nayak will apprise, Your Lordship.
You have received the copy of the application?
We have received the copy.
All right, Passover. Passover or next week it will be taken out?
It's a small matter, my lords.
All right, Passover. Next.
Item number 3.
May I please, Your Lordship,
Yes.
The petitioners are bona fide purchasers of some properties, my lord, two properties. But in the OBID Act, my lord, in the OBID code,
OPID case, my lord.
So have you given a copy to
No, he has
Mr.
given to us.
No, no, no. You should give it to Mr. Vivekanand Bhuiya and Mr. J.P. Patra. Mr. Tripathi, you hand over. I'm mentioning the names of the two learned counsel. It will come next week. Just intimate them. This case arises out of a proceeding under OPID Act. Instead of serving copy on Mr. Vivekanand Bhuiya and Mr. J.P. Patra, learned counsel who used to appear, special counsel who used to appear in such matters, copy has been served on the learned counsel for the state. Mr. Tripathi, learned counsel for the state, submits that he will hand over the copies to Mr. Bhuiya or Mr. Patra by next week, by Monday, by Monday. List this matter on 11th of August 2023, indicating the names of Mr. Vivekanand Bhuiya and Mr. J.P. Patra in the cause list. Yes.
item number 6.
Item 6, my lord, on behalf of Mr. Pradhan, kindly be taken up next week. We will remove the defects, my lord. So I have not served a copy to vigilance.
It's a vigilance matter. Who is appearing in this case? Vigilance counsel ke nahanti?
He has not.
We have not served a copy.
Okay. The learned counsel for the petitioner seeks for an adjournment on the ground that he has not served the copy of the CRLMP on the learned counsel for the vigilance department. When you will serve?
On Monday, we will serve.
Okay. Matter be listed. Serve by Monday. Matter be listed on 11th of August. You want it on 11th or 18th?
18th.
18th. 18/8/2023. Yes.
Item number 7.
May it please your lordships.
Mr. Chan,
Item number 10, my lord, on last occasion CD was called for, my lord.
available, CD available?
Yes,
Yes, argue the matter.
My lord, kindly taken up next week so that we can.
Okay. CD is available and counsel for the petitioner seeks for an adjournment. Adjourn. Yes, next.
Item number 11.
Next.
Item number 12.
Yes, Mr. Joshi. Why anticipatory bail has come to, it was earlier rejected?
No, madam, that almost all the matters are allowed by Justice Subhash.
No. Why this matter?
Must be placed before Justice.
This 1678.
3 of the matters was placed before Justice C.R. Das, court number 2. Last 3 matters it was.
No, I do not know this. Earlier I have disposed of.
No, madam, I have.
Yes. That is it. Reason. One, that is of the co-accused for us. One co-accused Rama Meher bail application I disposed of on 27/1/2022.
Madam.
So in connection with this case, several bail applications have been filed.
Yes, sir.
But maybe that yes, all these matters are 2012 matters.
12 matters, yes.
Right?
Yes.
Because the FIR
of the year 2012.
But all those honorable judges who has dealt with it might have been retired, so that is the reason why it has been placed before me now. All right. So in a 2012 matter,
yes,
in 2023, why are you seeking anticipatory bail? What is the status of the case?
There's a group class between member of scheduled caste and scheduled non-scheduled
that is not the thing.
Yes.
You
I'm an inhabitant of Latur, the local. Yes.
The charge sheet submitted in 2014.
Yes, madam.
So must have been this 80 to 83 process must have been issued.
So
once it is issued, anticipatory bail is not maintainable.
I'm cautious of the same.
So
you see, even though even the charge sheet, let's see the last page.
Last page is
only 3 to 4 persons have been charged sheeted in the present case, showing persons serial number 50 to 109 as
Mr. Tripathi,
yes,
you obtain instruction as to whether process under 80 to 83 CRPC has been issued or not. Yes. Since it is a case of the year 2012, in which charge sheet has been submitted on 10/9/2014, let the Land and Council for the State obtain instruction as to whether process under section 82 and 83 CRPC have been issued against the petitioner or not. Please this matter. So it will come on 18th. You obtain in the free copy of the order be handed over to the Land and Council for the state.
Interim order to continue.
What interim order?
Initially it was before Justice C.R. Das. 3 of the matters were disposed of, 3 were adjourned. And some interim order was passed. Lordship, see 7/7/2023.
Right. Interim order dated so and so. So continue till next date.
Obliged.
Item number 13.
May I please, madam? Let us deal with first page 15, answer 2. Rushikesh Karmi. My let us dealt with conducted ABLAPL 9809 of 2021, answer 2, page 15. That's why it has come before my lord. And other bail applications before my lord Justice C.R. Das.
So you have received the case record?
Yes, ma'am.
What is the allegation against this petitioner?
The petitioner is working as a clerk in some register office. Others who have been granted bail, either they have purchased or vendor or vending.
Connivance with other co-accused, he has manipulated some documents and sold away the landed.
No, those co-accused have been released on bail. What he submits? S.K.SAHOO
Yes.
is one of such co-accused who has been granted bail.
Another my lord, Vishwamitra Pradhan, page 18.
Page 18.
My lord.
They are given the regular bail, not
No,
anticipatory.
no, no.
No, no,
Anticipatory bail.
Anticipatory.
So, what you are doing now?
Clerk in sub-register office.
Code लिख Paragraph 7. Senior clerk in the sub-register office of Bir Maharajpur. Are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submits that the petitioner is now working as senior clerk in the sub-register office of Bir Maharajpur. The offences are triable by magistrate. Co-accused persons S.K.SAHOO and Vishwamitra Pradhan have already been granted anticipatory bail by this court in ABLAPL number 9809 of 2021 and ABLAPL number 14737 of 2022. And therefore, the bail application of the petitioner may be favorably considered on the ground of fairity and equity. Learned counsel for the state oppose the prayer for bail, considering the submission made by the learned counsel for the respective parties, nature of accusation against the petitioner, since the petitioner is a government servant and offences are triable by magistrate, taking into account the release of the co-accused persons on anticipatory bail, I am inclined to grant anticipatory bail to the petitioner accordingly. In the event of arrest, he shall be released on so and so.
Obliged.
କୋଉଟା ହଁ କଣ ସେଟା ଆଣିଲେ କି ସେ ଫାଇଲଟା 294 ଟା କଣ କି ମେନସନ କରିଥିଲେ Mr. Tripathi?
Yes, ma'am.
294
Yes.
file aଣିଲେ Yes.
Petition was published before the juvenile
If
court.
that case diary is available.
Yes.
Okay. So, you are in observation home since when?
17/12/2020.
17/12/2020. What are the offences under which charge sheet submitted?
Submitted under section 450.
Yes.
302 34 302 120B 201 34 of IPC.
120B
201 34 of IPC. And 41 of the which hunting act. Prevention of which hunting.
Since what is the date of occurrence?
Occurrence date on 16/12/2020.
So, how many persons are involved in this case?
Three petitioner involved, my lord.
3 persons.
3%.
What about the other 2?
Others,
You are a juvenile.
my lord. Other are major, my lord.
No, what happened to their status of bail?
He is in custody, my lord.
Both of them are custody.
My lord.
So,
And the petitioner is a lady, my lord.
and the other 2?
Gents.
Gents. So, what you have done according to eyewitnesses are there, Mr.
No,
Tripathi?
Yes, madam. I
What-
have not gone through that record.
Acha, all right. You go through it. We'll take up this matter next week. All right. Etaku learned counsel for the state submitted that he has received the case diary but has not gone through the same. List this matter on 11th of August 2023. Era supplementary report as you.
With Lordship's permission, Miller, Item 264, it's for restoration.
264.
It's a bail matter for restoration.
Wait.
ଏଇଟା ବି ଏଇଠି ରହିବ 2021 ର bail
264. ହଁ ଏଟା ରିଷ୍ଟୋର କରିଦିଅନ୍ତୁ।
ହବଲେ next week
After loss, there is
election.
No, election petition.
My lords, weekly item 2, my lords. It was passed over, my lords.
Maybe taken up next week, your lordship.
My lords.
Next week it will come. Yes.
Today we have filed an IA. Today we have filed an IA. Copy has been given to the other election petitioner. Prayer is to give us 1 week time.
For what purpose?
To file evidence on affidavit.
But when the evidence was closed from the side of the election petitioner,
Minor.
I think it is
On
about 2
20th.
weeks have passed in the meantime.
2.5 weeks, my lords.
So,
18 days.
and
And my lords, all these documents are their own exhibits. They have relied on that and cross-examined the RO. This is just a ploy to waste this honorable court's
Your
time.
lordship directed supply of certified copies of exhibit by 27th. But we got it day before yesterday at late hour. ଆଜି ତାକୁ ଆମେ ନେଇକିରି ଯିବୁ।
no, it's all right, but
there has been a delay of 5 days. ଆମକୁ
that
ସେତିକି ଦିଅନ୍ତୁ।
certified copy, you have to prepare your, you know that you have already filed your written statement, so you are aware that what your case is, so you can file it by way of an evidence affidavit.
Certified copies ଟା ନହେଲେ ତାକୁ evidence prepare ଆମେ କରିସାରିଛୁ। compare ତ କରିବୁ ପୁଣି।
So that is certified copy. You have already got those copies with you. Only this seal has to be given. Except that, what else you require?
ନାଇଁ କପିଟା ଆମେ ଆଣିଲେ ତାକୁ compare କରିବୁ।
My lords, with these documents, they have cross-examined the RO. They want certified copies of the documents on the basis of which they have cross-examined the RO. It is their documents, my lords. And then, my lords, certified copy may be just to compare whether it is the exact copy or not. It's a different issue. But those copies could have been utilized for filing the affidavit on chief.
Mr. Mishra, you know that a court was functioning just prior to the lunch. 200 odd matters are there. Mohammed Mukim, who is present in court today. Mr. Vidyadhar Mishra and senior advocate submitted that since there was delay in receipt of the certified copy of the exhibited documents, the evidence affidavit could not be prepared in time, and the matter may be adjourned to next week so that in advance they will give the copy of the evidence affidavit to the learned counsel for the election petitioner and file the same. Mr. Milan Kanungol and senior advocate oppose the submission made by the land counsel for the respondent and submitted that dilly-dallying tactics has been adopted to see that the judgment is not pronounced in the election petition at an earliest. Be that as it may, considering the submission made by the Learned Council for the respective parties, the averments taken in the interim application, the prayer made in this IA is allowed, subject to deposit of rupees 10,000 by Monday by the respondent in the High Court Welfare Fund, High Court Advocates Welfare Fund. The matter will be taken off on 11/8/2023 at 2 p.m. Learned Counsel for the respondents shall file the evidence affidavit, and the respondents shall remain present on that day to adduce evidence. Advance copy of the evidence affidavit given to the Learned Counsel for the election petitioner. IAB registered. That's all.
Obligation.